Hi guys! Welcome to another episode of Attorney Vlogger, Law for the Everyday Layman. Today we continue with the law on negotiable instruments, and we'll be talking about the discharge of the negotiable instrument as well as of the parties liable thereunder. Okay? So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Okay? So up until this point, we've been discussing several topics on negotiable instruments, including the incidents or the stages in the life of a negotiable instrument. From the very first issue, the making of the instrument, whether it be a bill of exchange or a promissory note, up to its negotiation, either through endorsement in case of an order instrument, or through mere delivery in case of a bearer instrument, up to the specific stages when it comes to bills of exchange, such as presentment for acceptance, which if refused, the need for notice of dishonor, and if accepted, the need for presentment for payment, and in the case of promissory notes, there is no need for presentment for acceptance, just presentment for payment, which if refused, also needs a notice of dishonor to hold the party secondarily liable on the note. Okay? Now, what happens if either presentment for payment in either bill of exchange or promissory note is accepted, meaning that the party pays? Then the instrument as well as the parties will now be discharged as a general rule. And what is discharge? Discharge is simply the release of all parties, whether primary or secondary, from the obligations arising from the instrument. Okay? It renders the instrument without force and effect, and in other words, the instrument, it can no longer be negotiated. Okay? Now, the law gives us the instances of discharge. Okay? So we have by payment in due course. Okay? Payment in due course by or on behalf of the principal debtor. Take note, under Section 88, in order for there to be payment in due course, it must be made at or after the time of maturity of the payment. Okay? It must be to the holder thereof in good faith, okay? And without notice that his title is defective. Okay? The second instance of discharge is by payment in due course by the party accommodated. Not the accommodation party, by the party accommodated, where the instrument is made or accepted for his accommodation. Okay? Why? Because the instrument is not discharged when the accommodation party pays. Why? Because the party ultimately liable as the real debtor is the accommodated party, or for whose accommodation the instrument was made. Okay? So if the accommodation party pays, there is still a real debtor who is liable, and that is the accommodated party. Okay? Next instance when of discharge, by intentional cancellation of the instrument by the holder. Okay? Now, for this to operate as a discharge, yung intentional cancellation, the cancellation must be intentional, and the intention to cancel the instrument is presumed. Okay? And the cancellation may be by tearing the instrument, by writing the words cancelled, or any other similar act. Okay? Again, the cancellation is presumed to be intentional, and second, the cancellation must be made by the holder. Okay? Now, I said that the cancellation is just presumed to be intentional. However, the party who is charged with the cancellation is entitled to prove that the cancellation was unintentional. Okay? He can show that it was done by mistake or without authority of the holder, and in which case, if it is proven to be unintentional, then the cancellation will be inoperative. Okay? So there will be no discharge, in other words, So let's move on. Okay, the next instance of discharge is by any other act which will discharge a simple contract for the payment of money. No, we have the grounds in oblicon. No, we have payment, novation, merger, compensation, etc. No, please just watch my episode on oblicon. No, on extinguishment of obligations. Okay. And the next ground, no, for discharge is when the principal debtor becomes the holder of the instrument at or after maturity in his own right. No, he is able to become the owner of the instrument. No, it may have been negotiated to him. No, so he is now the holder in his own right. Okay, and finally we have the situation of renunciation in favor of the principal debtor at or after maturity. Now, take note about this renunciation, okay? First, no, if the renunciation is unconditional and absolute in favor of the principal debtor, then the instrument itself, as well as all parties to the instrument, are now discharged, okay? But take note, if the renunciation is only in favor of one of the secondary parties, no, like one of the endorsers, I renounce my right to go after this specific endorser, okay? Then it only benefits, the renunciation will only benefit that particular party and those that are subsequent to him. So let's say XYZ, no? I renounce my right to claim against X. Then Y and Z are also benefited, no? In either case, no, whether it be in favor of the principal debtor or only for a secondary party, the renunciation will not affect the rights of a holder in due course who has no notice of the renunciation. Okay? Just take note of that, no? And in all cases of discharge, the instrument itself must be surrendered to the payer in case he will want to have recourse against the other parties, or in case it is the primary party primarily liable, then so he has evidence that the instrument is now discharged and the instrument will no longer be negotiated. Okay? Now, there are also rules when the parties who are secondarily liable can be discharged. Okay? These are additional grounds for discharge, but only of the parties secondarily liable. Please take note, this is important, that if the secondary party is discharged, it does not necessarily mean that the instrument itself is discharged, okay? So it may mean that only that secondary party and the party subsequent to him may be discharged. No, I'll discuss the rules, no? The first way secondary party can be discharged is by any act which discharges the instrument itself. If the whole instrument is discharged, then of course all the parties will be discharged as well. Take note again, this is different from the discharge of a secondary party. We're talking about discharge of the whole instrument, no? It's different from the discharge of a secondary party, which does not discharge the instrument itself, okay? Second ground for the discharge of a party secondarily liable, no? The intentional cancellation of the signature of the secondary party by the holder, no? So let's say XYZ again. Then the holder cancels the signature of X, okay? Then that secondary party, only X and the party subsequent to him are discharged, okay? The effect is as if the secondary party was never a party to the instrument, okay? However, this is very important, the right to strike out the signature and endorsement, no, is subject to the limitation that the endorsement is not necessary to the holder's title. I've discussed this previously, no, but as a review, no, just remember that you have to be able to trace your title. Just think of it like lineage of a family tree, no, you trace your ancestor, the ancestor of your ancestor, etc., no, your father, great grandfather, great great grandfather. Okay? So, in that case, no, if your title, no, the title that you hold can only be traced from Z, then you trace Z's title from Y, then Y from X, then you cannot strike them out because their titles are necessary for you to be able to say that you have a title as well. So you cannot strike any of their endorsements out, no? But in case of bearer instruments that are negotiable by mere delivery, okay, then you can strike out endorsements which are not necessary to your title because the instrument is negotiable by mere delivery. Okay? So, why? Because even if there is no endorsement, the instrument is still payable to the bearer. Okay? Please just review my episodes on the matter. Okay? So the next instance when secondary party may be discharged is by the discharge of a prior party through an act of the holder. Okay, take note, by the holder, not by operation of law like bankruptcy, insolvency, prescription, or failure to give notice of dishonor. Okay, it has to be an act of the holder. Why? Because the discharge of that prior party deprives a subsequent party of a right of recourse against the party discharged by the holder, meaning that subsequent party can no longer run after the prior party. So all subsequent parties to the prior party who was discharged will now be relieved as well or discharged. Okay? The next ground for the discharge of party secondarily liable would be by a valid tender of payment, no, made by a prior party. Okay, valid tender, no? When I say valid tender, of course, it has not produced the effect of payment yet. Okay? In other words, that tender would have produced the effect of payment in due course and would have discharged the paying party had the holder accepted, no? The refusal of the holder of that tender without valid reason will of course discharge the prior party and all the subsequent parties, no? Subsequent parties are discharged again because they are deprived of the right to run after that prior party who was discharged. Okay? Next ground for the discharge of a party secondarily liable by a release of the principal debtor. Okay? If the principal debtor is released, I relieve you of your liability. No, you are free. Okay? That is a ground for discharge. However, take note, no, that this will not apply if the holder expressly reserves his right of recourse or right to run after any party secondarily liable. In other words, no, if the holder says, I release you, party primarily liable, except that I expressly reserve my right to go after endorser X. Okay, in which case, that secondary party will not be relieved nor discharged. Okay? And finally, the last ground for which party secondarily liable can be discharged would be by any agreement binding upon the holder to extend the time of payment or to postpone the holder's right to enforce the instrument. Okay? However, this is subject to exceptions, meaning these are the instances when an extension will not discharge a secondary party. First, no, if the extension is made with the consent of the party secondarily liable. Okay? Of course, no, the extension modifies the contract of the party secondarily liable. So he has the right to object, no? But if he consents, then the extension of the payment of the instrument or the postponement of the holder's right to enforce the instrument will now bind the party secondarily liable. Okay? Now, the second exception to the rule is that when the holder expressly reserves his right of recourse against such party. We talked about this just a while ago, no? Okay? Now, those are the grounds, no, for when party secondarily liable will be discharged. Okay? Now, if a party who is secondarily liable pays the instrument, take note, the instrument itself is not discharged. I've been repeating this, no? The effect is simply that it will cancel only the secondary party's own liability and that of the parties subsequent to him. And he may now strike out his own and the subsequent endorsements. Okay? However, no, take note that the striking out in this case, no, since he is discharged, he can strike out his own signature and the endorsements of those subsequent to him. He cannot do that in the following instances. First, no, if the instrument is payable to the order of a third person and it has been paid by the drawer. And second, where the instrument has been made or accepted for accommodation and has been paid by the accommodated party. Why? Because in these two cases, the instrument is now discharged, no? The party primarily liable has already paid. So there's no more reason to strike out those endorsements, okay? So that's it for discharge, no? It's very short, no? Next episode, we'll talk about checks. And after that, I'll release an episode on special problems in negotiable instruments where we will see how to apply the rules that we have just learned. Okay? I'll be giving some examples and situational scenarios. Okay? So I hope you may have picked up a thing or two, and I hope to see you in the next episode. No? Please please share this channel to those who may need it, no? Because negotiable instruments is a very hard subject to study. I myself had a hard time studying this when I was back in law school, okay? So, please share this as well as my other playlists, no? To those who may need it, and let's try to help all we can, okay? So, I hope to see you next time, and see you soon, guys. Bye.